5 second. Start. Leave granted. The appellant has assailed the final judgment dated 6th January 2020 passed by High Court of Jharkhand at Ranchi in criminal revision number 1057 of 2018, by which the order dated 4 July 2018 passed by learned special judge anti-corruption bureau dismissing the application for discharge filed by the appellant under section 239 of Code of Criminal Procedure 1973 for short CRPC in connection with special case number 2 of 2011 has been affirmed. The criminal case was registered against the appellant and others for commission of offences under sections 109, 409, 420, 467, 471, 477A and 120B of Indian Penal Code for short IPC and section 131C and 131D read with 132 of Prevention of Corruption Act 1998 for short PC Act. The facts briefly put are that the appellant was working as executive engineer electrical in the Accelerated Power Development Reforms Program wing of Jharkhand State Electricity Board, in short JSEB, from 7 December 2004. During his tenure as EE1, Ramji Power Construction Limited, hereinafter RPCL, was awarded a contract of work under APDRP with a work order dated 27 January 2005. On account of delay in execution of the work and to resolve the said issue, the then chairman JSEB, Mr. Shivendu, convened a meeting on 21st December 2006 wherein he orally instructed Mr. R.P. Agrawal, the then chief engineer, to place the agenda for next board meeting for termination of the contract of Messrs. RPCL. Prior to convening of the next board meeting, Mr. V. N. Pandey was appointed as the new chairman JSEB on 4th January 2007. The new chairman called for a meeting on 6th February 2007, 7th February 2007 for the agenda to review the progress of RPCL's work. In the said meeting, other officers of JSEB, including Mr. R.P. Agrawal, CE, had participated. In the meeting, it was mutually agreed by JSEB and RPCL that full effort to complete the work within the extended time, that is July 2007, shall be made by RPCL. In furtherance of the decision taken in the aforesaid meeting, Mr. R.P. Agrawal, CE, made various correspondence reminding RPCL to complete the pending work. On retirement of Mr. R.P. Agrawal, Mr. S.C. Srivastava, Superintending Engineer Electrical, was made in charge in place of Mr. R.P. Agrawal. Meanwhile, RPCL sent letters dated 16th May 2007, 18th May 2007, and 18 June 2007 requesting him for further extension of time. In the said correspondence, it was said that RPCL had already invoked the arbitration clause on 22nd December 2006 in terms of the contract and requested JSEB for appointment of an arbitrator. The said letters were handed over to the appellant, on which, under the instructions, the appellant prepared a note dated 8th June 2007 and placed it before the chairman on the issue relating to appointment of an arbitrator and waiver of penalty as advised by learned advocate general of state of Jharkhand in similarly placed transmission lines projects. Thereafter, with a JSEB resolution dated 28 June 2007, a committee consisting of one Mr. G.N.S. Munda, member technical, Mr. A. Banerjee, finance, and Mr. A.K. Mishra, law officer, was constituted, which on 19 August 2007 suggested three names for appointment of an arbitrator. Out of the three names as suggested, Mr. Ramayan Pandey was appointed as the arbitrator by consent. Arbitration proceedings commenced and an interim award dated 25th 11 2007 was passed in favor of RPCL. Thereafter, an agenda accompanied with the aforesaid award was put before Chairman Mr. B. M. Verma prior to asking for an opinion from the AG, State of Jharkhand, regarding enforceability of the award. Later, as per the opinion of the AG JSEB, with a board resolution dated 5 April 2008 and 7th April 2008 decided to implement the interim award. It is worthwhile to state that Mr. GNS Munda, member technical, as well as Srimati Rajbala Verma, then Finance Secretary State of Jharkhand, were part of this board meeting. It is pertinent to mention that while giving effect to the award, JSEB was facing shortage of funds. However, JSEB decided to make internal inquiry into handling the work contract given to RPCL. On the basis of the said inquiry, allegations of malpractice and financial irregularity were leveled against the appellant and some others. The Secretary JSEB Vijay later dated 30th July 2010 made a request to the Director General of Vigilance Bureau DGP to lodge an FIR against the appellant and others for offences punishable under sections 109, 409, 420, 467, 471, 477A and 120B of IPC and section 131C and 131D read with 13.2 of PC Act. Additionally, another letter dated 3 September 2010 was issued by Srimati Rajbala Verma, then Vigilance Commissioner, to the DGP recommending the same action against the appellant. As already noted above, Srimati Rajbala Verma was also a part of the board meeting, being the then Finance Secretary State of Jharkhand that had approved the implementation of the arbitral award. In the said facts, FIR dated 20th January 2011 was lodged against the appellant and other officers of the JSEB. Investigation was carried out. Charge sheet dated 8th January 2016 was filed and cognizance was taken by the court dealing with vigilance cases with a order dated 11 January 2016. Thereafter, the appellant moved a discharge petition under Section 239 of the CRPC, which came to be dismissed by the learned special judge with a order dated 4th July 2018. The court observed that sufficient material exists to make out a prima facie case against the appellant for framing of charges. Agreed by the same, the appellant preferred a criminal revision assailing the aforesaid order. The High Court with a impugn order dismissed the revision and affirmed the order passed by the learned special judge. The High Court was prima facie influenced by the fact that the previous chairman, JSEB, Mr. Shivendu, had orally instructed to put up the agenda for termination of the contract of RPCL. On demitting the office by the said chairman, the appellant had put the file noting before the subsequent chairman, Mr. V. N. Pandey, regarding referral of the matter for arbitration without mentioning about the instructions given by the previous chairman JSEB. The High Court found fault in the action of the appellant of having proposed an agenda regarding wrongful implementation of the award, which was challenged belatedly. Thus, having found a prima facie case against the appellant, the High Court dismissed the revision petition. Learned counsel for the appellant, Mr. Prashant Bhushan, strenuously urged as under: the appellant was not having decision making power or financial authority to carry out the contract and the award passed. The nature of duty assigned to the appellant was confined to follow instructions of his superiors, and by no stretch of imagination he can be said to have the power to refer the matter for arbitration in a case where the dispute is arising out of a work contract between JSEB and RPCL. There is no concealment of the instruction of the previous chairman pertaining to termination of the contract as substantiated by noting dated 8th June 2007 on page number 48 of the APDRP file, which was the next page of noting of the CE on page number 47 under instructions from the chairman. Stop.